No one's in it except me, so you might be in a little bit. But
Not anymore.
so first, let me thank Justin, the man out there, for allowing me to come here. Thank you. He heard this this presentation last week at the Coral Springs location. So my name is Justin Stivers. I'm a probate attorney. I own a law firm in downtown Miami. We operate statewide. All we do is probate, so we don't do title, we don't do real estate, we don't write wills, we don't write trusts. We deal specifically with probate. And probate I'll get into, but it's after someone has passed away. I'll go through that. And so this presentation, what I call Probate 101 for Realtors, is really a broad overview. I'm going to try to keep it right at 60 minutes, get you all out of here on time. But I just want to kind of have three main points. First, so that you all can locate when a property has to go through probate, so you can identify it. Second, when you go to a listing presentation, how you can really stand out from other realtors, just have enough knowledge about probate to kind of differentiate yourself. Obviously, I can't tell you every possible thing about probate just in 60 minutes, but I want you guys to have enough information, and I think if you all just have a working knowledge of some definitions, some key definitions, I think that will go a long way to help you all stand out. And then lastly, I want to give you all just kind of marketing, prospecting tips, because at the end of the day, you all want listings. So I'm going to, I think probate is kind of it's been trending for a little while in the realtor community, but I think it's kind of still a very untapped niche. And so I don't know if you all, if you each have your own specific niche or something that you work on, but I think there is a market to really go after properties that are going through probate. So we'll talk a little bit about that. Let me just pass this around real quick, just since I know some people have to leave. If you all would, just print your first name, last name, and email address so that after this, like I said, I can send you all the video, and then also give you all some free resources as well. And then I will pass these around. So this is just, if you want, take notes. This has a couple of the key definitions defined that I'm going to talk about, and then I just left some blank space so you all can make notes. I did this, I've done this presentation several times, and I'm sure you all are going to have a lot of questions. I'm happy to answer any questions that you all have. So please just raise your hand and shout at me, and we'll discuss. I'm sure there's a lot of stuff most likely that, we're not going to be able to get to. There's, it's just too big of a topic to do this in 60 minutes. If there's something, like the last group, they were really interested in trust, setting up trust and that sort of thing. So I said, hey, if there's enough interest and Justin wants, I'm happy to come back and talk about that. So if there's something that we don't touch in this course, because it's really just the 500-degree view, 360-degree view to overview. But if there's something you all want more information on, just let me know, and I'm happy to either send that to you or we can set up something. All right, so that's me, that's the presentation. I want to kind of get a feel for who's in the room, just so I kind of know your all's experience. If you would, just, we'll go around the room, just state your name, how long you've been a realtor, and then if you've ever dealt with a property in probate and what that experience was, good, bad, ugly, whatever the case may be. So we'll start here.
Okay, my name is Miriam Zamani. I've been in real estate for 14 years.
Okay.
I've never had a probate situation.
Okay.
My name is Jerry Noel. I've been with Berkshire or real estate in general since November, so I'm the new guy.
Okay.
I'm still learning.
Welcome. You're still here.
We all are still learning.
Yeah.
I know, whenever I stop. Gigi, Whitehead, Giselle. And I am maybe 12 years, back and forth.
Okay.
So, well, I like it what I'm doing, and I never been in this class before. I
Okay.
tried that, but
Okay.
that's it.
Go back to the gentleman in the back.
My name is Philip. I'm in the business 32 years.
Wow. Okay.
Still learning.
Great.
And court-appointed legal guardian for somebody who just passed away last year.
Okay. Great.
Hi, my name is Rachel. I've been a realtor for now 2.5 years.
Okay.
And I have dealt with an issue on probate, but joint rights of survivorship
Sure.
on there. So it really,
Didn't go through probate.
yeah,
Okay.
that's the only thing I've ever had to do.
Okay. Great.
I'm sorry, I'm not coming back to get coffee.
All right.
Oh, excuse me.
All right.
Hi, my name is Liz Blackman, Billhart now. I've been in the business since August 1978. Going
Okay.
41 years.
A couple years, all right.
Yeah, I've dealt with probate with my parents
Okay,
and a few other relatives
okay. So on a personal,
on a personal
Gotcha,
basis.
okay.
And right now, my husband and I are doing a trust
okay, great,
with right of survivorship and stuff like that.
okay.
It's very involved.
Yep, absolutely.
Like 17 pages.
More than what you thought.
Yes, yes, it's really
Okay.
involved and intricate.
Okay, great.
Thank you.
Great, thank you.
Hi, good morning, everyone. My name is Maria Cecilia. I'm just new in this office. I'm just trying to know if I'll be able to make a decision to join you guys. But I've been in the business for since 2005.
Okay,
Yeah. So
great.
I never had any experience with
Well, if you end up joining, tell Justin it was because of my presentation. So give me good brownie points.
all right, sure. I will.
I'm Barbara Lane, and I have been in the business since '95, and I have had a deal with probate, which ended up extending
Sure.
the deal for quite a while.
Okay,
Sandra Pereira, I've been in the business for about 13 years, and I've never dealt with any probate properties or any deals with that.
okay,
Tiffany Cominali, 14 years, and I have a probate right now with where the heirs have a dispute and the property's in foreclosure and she just filed bankruptcy.
Oh, boy.
common-ish. I guess I should thank Tiffany as well. She's the, I guess, conduit how I got into here. She introduced me to Justin, so thank you. Okay, great. So we've got some newish people, or very new, and then a very seasoned group of realtors, so that's awesome. And it sounds like kind of a mixed bag. Some on probate on the personal level, some just, having the bad part of the probate, conflict and litigation, that sort of thing. Okay, so what I'll start with is I just want to give you guys a key, a couple key definitions, and we'll start with what is probate, because that term gets thrown around a lot. The way I describe probate, or I think the best way to think about probate, is it's a court process. It's a legal process. So, our firm's tagline is we help people get their inheritance after the loss of a loved one. So it's kind of, in your world, the process is getting the property transferred from the name of the person who passed away to ultimately the person who's going to be able to sell the property. And that process goes through probate, which is a legal process. So there's a court case number, there's a judge involved. There are ways to avoid probate, which I'll touch on a little bit, but just broadly speaking, probate is a legal process. So when you hear the term probate, if it's used correctly, that means it's going through the court system. Decedent, that's really just another name for a person who's passed away. It's a term that we use a lot, but decedent is just the name of someone who's passed away. Estate, you'll hear this term a lot, especially if you're selling the property. I think the easiest way to think about it is the estate is what encompasses everything that the person passed away had. Any assets they had, any liabilities, it's essentially their new name. So for example, let's say John Smith. John Smith is the name of the person. He died. When he dies, everything about John Smith is now going to be called the estate of John Smith. So when you hear an estate, when you hear the word estate, it's just basically everything, property, it could be money, it could be credit card, debts that he has, a mortgage that he has. Estate is like the umbrella, and then everything that he or she had falls under the estate. Okay? Last will and testament. This is pretty common, or just known as a will. A will is really a legal document, but it could be, there are some rules as to what constitutes a valid will, but it could be me, writing a piece of paper, writing it down, saying I leave everything to, my children when I die. And if it's done properly, that could be a last will and testament. So, this is like, most people think, this is kind of like an aside, which I'll get into, but for your all's knowledge, and I'll touch on it more, but a will does not avoid probate. So it's kind of a common misconception where you might go and someone tells you, hey, my dad just passed away, but he had this document, he had a will, says that I get the property, so we don't need to go through probate. If all they had was a will, it's still going to go through probate. And I'll touch on that a little bit more. But a will, if the person just had a will, it's not going to avoid probate. Yeah? Okay. And then the personal representative, also known as an executor. They're the same word. It's the same term. So a personal representative is the term that we use in Florida. Other states, I think New York uses the word executor. But if you're speaking with someone and they're saying, yeah, but I'm the personal representative or the executor, it means the exact same thing. And the personal representative is important for you all because the only person who can sell the property on behalf of the estate is the personal representative. So if John Smith dies and now that property is owned by the estate of John Smith, that property cannot be sold until the probate is open and a personal representative is appointed. Am I overwhelming you all right now?
No,
okay.
no, that's good.
Okay. Okay. Yeah. Like I said, if it's confusing, I mean they're kind of legal terms, and I'm trying to make them as simple as possible. But these are the most important terms I think that you'll come across. So the personal representative, in my world, that's the person I'm usually working with. So as an attorney, I'm working with the personal representative. And similarly for you all, when you go to sell a property or get a listing agreement, you're going to want to work with the personal representative.
It's an attorney, right? The personal representative is an attorney.
No.
It has to be an
No.
attorney, no? Okay.
It's like an assistant of the attorney kind of.
No, so the personal representative almost always is a close family member, usually.
Oh, I see.
It's so
Okay.
no, the attorney is usually not the personal representative. They can be, but if you have a will, you're gonna name, so let's say, my example, me and my wife, we name our child as personal representative. So when we die, our child is now the personal representative. You can name whoever if there's a will. If there's no will, then it's usually, the way to think about it, it's the closest living relative. That's usually going to be the personal representative. It can be an attorney, but it's not as common. It's usually a family member. Usually, yeah.
But sometimes who are like this, like my husband, maybe they choose attorney, right? If they never
He could, I mean, if you and your husband have a will, he could, I know it's always it's a sensitive subject because we're talking about people passing away, but your husband, most likely, he could choose somebody else. But if you guys don't have a will, then you would be the personal
So
representative.
it doesn't really have to be necessarily a member of the family. It can be anyone that you assign as far as it's on writing.
If you have a will, yes, you can choose whoever you want.
Whoever you want.
If you don't have a will, there's law that's going to say who's going to become the personal representative. Yeah.
Court appointed. Okay, that probate.
Court appointed, right?
It's not normally court appointed, no. So there's a hierarchy. So, and I'll touch on this in a second because these are good questions and it's very relevant. But let's say, I'll just give you all an example. If there's no will, this is assuming there's no will. So someone passes away, if their spouse is alive, he or she would be appointed personal representative. Okay? If there is no spouse, then one of their children would be appointed personal representative. If there are no children, then their parents would be personal representative. If there are no parents, then it would be the brothers and sisters who would be personal representative. If there's no brothers and sisters, it'd be aunts and uncles. So there's like a hierarchy as to who gets appointed. Depending on the situation, I mean, I could give you 1,000 different situations where, yeah, there could be a court-appointed, guardian in a guardianship case, or there could be an attorney, but usually, let's just say 8 times out of 10, you're either going to have a will, and the will's going to say who the personal representative is, or you're just going to go by the hierarchy, and that person
So
will be
the only way the attorney can be a personal representative is when the person does not have any members or at all, no family. So the last person would be the attorney then.
No,
No?
I don't want to get down too far, like too technical side of it.
Or like when there's 5 kids involved and maybe the
They don't have no
person
one.
knew that there would be problems with the 5 kids. So then they're
There's-
sending somebody.
Yeah,
right?
it could be if there's problems. I mean, you have to go down a very long list. For example, we have one, and I'm going to talk about this example, but there was no spouse, there were no children, there were no aunts and uncles. It got down to the second cousin. So the second cousin is the personal representative. So you go down you don't just automatically go to an attorney. You have to it wouldn't happen where you would run out of family members. You would have to ask the court, yeah, you're going to find somebody. Or something like that. But yeah, it's not as usual as that it's going to be the attorney. Okay, so number one, so kind of the first point that I want to talk about, how to determine whether a probate is even necessary. I'll ask you guys, so when you are, let's just say someone calls you, a family friend says, hey, my friend has a property they want to list. Great, awesome. What's the first thing you all would do? They give you the address, what do you all do?
Go to the title. Go to the title, see who is the owner.
Okay, yeah. So that's normally what you're going to do. You're normally going to go to the property appraiser's website, county appraiser, tax appraiser, whatever, and figure out how the property is owned. So I'm going to give you all a couple different examples here. And these are probates that we're doing, that we've done, real life examples. I'll just pass them around. You can just give me the extras back. Okay. So this is an example of someone who passed away, and there's really no rhyme or reason when the county is going to know that the person passed away. Sometimes, maybe a family member alerts it, or the death certificate gets recorded, but I can't tell you, I don't know specifically how the county knows all the time when someone's passed away, but usually a month, 2 months after, they're going to get notice, and they're going to change the owner of the property to reflect the estate. So this is an example right here where you can see now the owner shows Maria Pichardo, EST, is EST of. So what that means is that she passed away and her estate, EST, stands for estate. So in this instance, not 100% of the time, but I would say like 97% of the time, if you see this on the property appraiser's website, this is going through probate. So this woman did not have the property was not in a trust. There was no deed that left it to somebody else. So we had to change this we had to open a probate, and this property is now in the name of her daughter. But a probate had to be opened in order to transfer the name. So in your all search, when you guys are, researching the property, someone gives you a property and you come across does everyone see what I'm talking about? Owner, Maria Pichardo? Okay.
What am I looking for? I'm sorry.
Yeah, so like 3 lines down, it shows owner, Maria Pichardo, EST of. So that means that the property is owned by the estate.
Okay, thank you.
So whenever you see that on one of these on the property appraiser's website, you can almost guarantee that a probate's going to have to be open. So this is going to be, should be a red flag, and it's going to change probably how you approach this deal.
So how long does it take them to write the bills?
I'll answer that in the second section.
Okay.
Yeah.
So what if it says Maria Pichardo or the estate of Maria Pichardo?
Or the estate of?
And the estate of. Like, sometimes you'll see a name and then the estate. Is it always, if you see estate, they already died?
If you see estate, they already died.
There'd be trust, maybe.
I'm going to show you a couple different examples. But this one is just, if you see, I'm not sure your example if you see or, but if you see this and it shows EST of, that means estate of, which means this person had already passed away and the property is now owned by the estate. So you've got to do a probate to transfer title. This next example is kind of a trickier one. So this one shows the owners. There's 2 owners. It shows the estate of Jesus Silva and then Maida Silva.
That's what I'm talking about.
Okay. So in this case, what this means is this property is owned 50-50. There were 2 people on title. They didn't have it deeded, titled in a way. So this is one that we're doing actually right now. Maida owns the property. Maida is still alive. She's the daughter of Jesus. she's still alive. Her father, Jesus, passed away. This was an investment property. In order for her to sell that property, we had to open a probate to get the 50% interest of Jesus now into her name so that she has full ownership of the property. Because if you see this, and this is actually real life, Maida didn't know that she couldn't sell the property. Okay? The realtor thought Maida could sell the property because she saw Maida Silva on here. They got under contract, they go the process, title comes back and goes, wait, you can't sell this. Because she thought she could sell, I don't really know what they thought, but they thought they could sell it. But now it has to go through probate. We have to transfer Jesus' interest to the property into Maida's name, and now they'll be able to sell it. So this is something to be, I guess this answered your question, yeah. So when you see something like this, and this happens a lot, because a lot of times people just don't know. They think that the deed, which someone mentioned, joint tenants with right of survivorship, that's a way to avoid probate, and I'll touch on that in a second, but sometimes people think that the way the deed is written is going to avoid probate. So a lot of times you'll see this owner, and they'll think, well, I was on the deed, I can sell it. But they didn't realize that they owned it with somebody else who's now passed, and so they've got to go through probate to basically transfer that person's interest. And this becomes problematic. In this case, it's fine because she's the only heir and it was her dad. But where you have problems is if this wasn't her dad, if this is, let's say they were partners, business partners, and now someone dies, now that business partner's heirs are going to inherit the property and they might not want to sell it. And then you've got issues, which I don't know if that's what you all have now. But fortunately, this was or for example, let's say Jesus had 3 children. And now now Jesus' interest is going to be owned by 3 children. And if they don't all agree to sell the proproperty, now it becomes kind of problematic. I know I'm throwing a lot at you, so if you have questions.
Probably take more time and all that dispute. Right?
It's just, unfortunately, when people pass and people see a house, they automatically, the money lights go off and they think they're going to get a lot of money out of this. And they think, they want to use their realtor. They think the property is worth, $1.2 million when it's a $200,000 property, or whatever the case may be. So it can be problematic. I'll touch on that just because I mentioned it. So there are a couple ways to avoid probate by using the deed correctly. One of those is to title it joint tenants with rights of survivorship. Does everyone know what that is or not really? Okay.
Well, I remember it in the state exam.
And I'm not a real estate attorney. I don't do closings or anything like that. But joint tenants with right of survivorship is a way that you can have the deed written so that it basically says, Justin Stivers with my wife, Alexandra Stivers, in joint tenants right of survivorship, so that when I pass, the property automatically goes to her, and you avoid probate. So that's one way to do it.
I have a question. Now, let's say you're on a property with someone, a family member,
Sure.
whoever, right? And they pass, and you don't have it. They don't have a will or anything.
Right.
That's another, because you could end up, right, having to, if there's an estate involved, right? Let's say one person has an estate, and you're involved in it, and, you might have to buy out their half sometimes, correct, right? If there's an estate involved, and
So it's
like the parents on there with one of the kids, and it's their property. They need to have it documented, so if anything happens to the parent, it doesn't go back into the estate. Because this was something that they had with the one member of the family, not the whole family, just that transaction. Does that make sense?
I'm a little confused, but what I would say is the estate is only open, you only have an estate when someone has passed away.
Right.
So it's not, you don't just, it doesn't just automatically go to an estate. So in that example, let's say parents own the property, and are you using a real life example, or?
Well, I knew somebody, this is a while back though, with the situation to where the parent was on there. When the parent died, they had to buy out the part of the estate with the other siblings, because if there wasn't a will, or,
Right.
you know, the mother
So
died
normally-
like very unexpectedly at a young
Yeah.
age, you know, in her 50s or whatever.
So what normally happens in that situation, let's just use that example. So
Yeah.
mom and dad die, okay, and now they have 2 children, John and Jane, all right? You open an estate for the parents, all right? And now when you transfer the property through probate, the property is going to be owned 50-50 between the children.
Right.
At that point, it's like another real estate transaction where you have 2 people on title. If he wants to buy out her interest, go for it. If she wants to buy out his interest, they can do it. Otherwise, the properties are going to be sold. They're just going to split 50-50. But if there's no will, you can't. It's hard. You don't really put on the deed itself. When we die, we want my son to buy out my daughter, or something like that. That's a much more complicated kind of way of doing
That was
it.
the problem, that it shouldn't have been like that.
Yeah.
It just was, because that's the way the probate attorneys made them do it.
Yeah.
You know what I mean?
Well, normally if there is no will and the parents die, it's going to be split between the siblings equally. And then at that point, it's up to them what they want to do with it.
Right, right.
So the will avoid all this.
A will does not avoid all this. A will does not avoid all this. What does avoid this, or what can avoid this, is like I said,
The
the
contract, what is
Joint
the
tenants.
right?
joint tenants with right of survivorship,
Should I
absolutely.
get points?
And
I am paying attention.
and this right here, so this is another one, which I forget your name, but you mentioned you and your husband are doing a trust right now. So I don't know if it's finished or not.
Yeah, it is.
Okay, but so I would double check. I mean, just make sure. If it's done with a trust, the property needs to be put into the trust. So this one right here shows the owner as Karen S. Rodman, TRS, and then herself as a beneficiary. So this means that the property is now owned by the trust. So when she passes, whatever the trust says, that's what's going to happen, and it's not going to go through probate.
Right.
So a trust will avoid probate. A will does not avoid probate.
I'll trust.
100%, a will does not avoid probate.
If it's in a trust and say she decides to sell it, is she's still alive and kicking?
Yeah,
She can sell it?
sure. Yeah, yeah. The trust is the most, because you're alive when you create the trust, right?
Yeah.
So you can do whatever you want. Like you can have creative trust where you say, when I die, I want my property, I want $1,012 to go to this person, the rest to go to this person. And while you're alive, you can change the trust to do whatever you want with it.
And you can leave your daughter-in-law out of it.
You can disinherit people, no
Yeah.
issue. Yeah.
That's the main
That's what they're
difference
doing
between
right now
trust
with
and a
the-
will.
Yeah.
Because it's like, if you
Or-
can write a trust,
Who you don't
and
want.
you can, do you need to do a will too? Or if you have a trust, you don't need.
Not really. No. Wills are, they're not worthless. They're better than nothing if you there's a specific thing that you want to do. So if the law is pretty clear as to who gets what if you die without a will. So if you've got 3 children and you want your 3 children to get everything equally, you really don't need a will. But if you don't like one kid and you don't want them to get anything, then you're going to want to do a will. A trust is a more complicated thing, and I don't know that they're good for everybody, but they're just stronger. They will avoid probate. And again, like I said, I don't want to turn this into like too technical, but a trust works for some things. If you have a mortgage on the property, generally you can't put the property in the name of the trust. So there's complications with it, but just generally what I wanted you the takeaway from this is that if you see EST or estate of, it's going through probate. If you see TRS, it's a trust and it's probably not going through probate. Yeah.
I don't know if you'll touch on it later. When do you know, I know they search for family members, but I forgot the real estate term, but when it's 100% just owned by the local government, when does that happen and how does that?
Almost never.
Never? Okay. So
Yeah. Yeah, it's property going to the estate. It would go to the estate because you haven't been paying property taxes, and then they'll just foreclose to take the property back. But it's not like there's not really 10 years and then they're going to take it. You would lose it before then for not paying property taxes, most likely.
Okay, if you see an estate, say for example, this one or this one, and there's other family members living in the house, and somebody dies who was part owner, is there a time frame where they actually have to sell it, or can they just keep living in it and then it just triggers when they want to sell it?
They can keep living it as long as they want,
And
as long as they're paying.
As long as they're paying taxes, you know.
I get that. I would say a large part of our cases are like that, where, you know, kids are living in the property, they don't have any, you know, they don't want to sell it. The main reason why, you know, if I have a prospect and they're saying, you know, why do I want to pay you to do this if I'm going to keep living, is, well, you probably can't get property insurance on it because the property is not in your name, so you're not going to be able to insure the property. But for whatever reason, South Florida, Miami specifically, people don't really care. They're like, whatever. Okay, so all right, so now you've determined that probate is necessary, right? So you've done your research, you maybe, you know, asked a probate attorney, but at least you've looked at this and you can kind of tell. When you go into the listing presentation, there's a couple, and we've touched on this a little bit, but there's really three things you want to ask this person. Was there a will? And the reason you want to ask them if there was a will is because if there's a will and the person you're speaking to is not named in the will, then you're kind of wasting your time speaking to that person, right? So if you're speaking to, you know, James, and his parents, you know, James's parents left everything to Vicky, you know, James doesn't have any right to that property. So you want to find out if they have a will. Just to, you know, dot your I's, cross your T's, and make sure you're speaking to the right person. If they say, yeah, my parents have a will, ask them, do they have a copy? And if not, can they get a copy? Reason being is, a lot of times, someone will say, oh yeah, you know, I was living with my dad, he had a will, or I was living, you know, with my brother, he had a will, he said I get everything, I can't find it, right? I don't know where it is. That's a red flag that maybe this person isn't telling the truth. It's not 100%, but if there is a will, because I get a lot of calls like that where, you know, oh, I think and it's usually when it's not a close family member. It's usually when it's like the brother or the uncle, and they're like, yeah, but I was taking care of him while he was really sick. I've been living with him in the home for 10 years. His kids abandoned him. I'm pretty sure he wrote this down. I just don't know where it's at. Well, we need to find that. I'm not, you know, you guys necessarily as realtors need to investigate more after that, but when you go to speak with the attorney, or when you are making sure before you get this person under a listing agreement, that's useful information. So, was there a will, and do they have a copy, and can they get a copy? The second thing you want to ask is, and kind of along the same thing, is what's your relationship to the person who passed away? Because again, how we, you know, talked about earlier, that there's a hierarchy as to who gets what. If you're speaking with the third cousin, well, you know, it's not impossible that that person's entitled to the property, but it's kind of unlikely. You know, majority of people, they either have a spouse, they maybe have children, they maybe have parents, they maybe have brothers and sisters or grandparents. Most people have, whether or not they're close with them or can find them, most people have somewhat immediate relatives that are around, that are findable. But if you start getting into, this was my, you know, stepmother's third cousin, whatever, I would want to dig a little bit more. And again, this is because you want to make sure you're speaking with the right person, because you don't want to go to a listing agreement or go to a listing presentation, get a listing agreement, go under contract, and then find out that this person has no right to sell this property anyways, and you waste all your time. So these questions are really to make sure that you're speaking with the right person. You know, one example, real life example that we were doing, and this is the extreme of it, but an investor found a property. There were people living in the property, and he offered them, you know, cash. $60,000 we want the property. They're like, yeah, great, okay, but there's a probate. We need to go through the probate. By the time it got to me, the investor was convinced that this woman was legitimate, that she's a real person. I speak with her. There's some like discrepancies. Long story short, after I investigate, she has no relationship to the person who passed away. She was just living in the property. She wasn't a squatter. I think she was maybe kind of at one point a tenant, but she had no rights to the property. And unfortunately for this investor, he had already, spent a lot of money, spent a lot of time, paid her some money, which is
But she
his
can
fault.
be a owner if she's living in the property more than how many years? Or she
Yeah.
continue to pay the taxes?
Yeah, there's it's like 7 years. That's a very complicated thing, but she wouldn't have qualified for that. Like she would, there was a variety of reasons, so she was not the right owner. But and it's very rare, I think, that someone's going to deliberately try to trick you when they know that they're not the person who's going to be entitled. But it happens. I mentioned that I have a client who's a cousin and is now able to sell the property. Well, this is somebody, a realtor in Miami, was knocking doors, happened to come across a lady. She's cleaning out the property. He's like asking her questions. She goes, yeah, my cousin passed away. He had never done probate before, so he asked his broker who referred him to me. I did some research. She legitimately, this guy had no other family. The cousin she lives in Tampa, is her closest living relative, so she is entitled to the property. But that's also kind of rare. It's usually, most of the time, it's going to be a son or daughter, a spouse, aunt or brother, sister. Like those are usually who's going to get the property. So when you are going to this listing presentation or you're on the phone asking questions, did they have a will? If they have a will, great. Do you have a copy? Can you get a copy? And then, what's your relationship to the person who passed away? It's really to protect you all and not waste your time. Okay, so part number two of 3, so we're getting close. How to successfully guide your clients through the probate process. So this probate is a little bit, I think, different from other listing presentations, only in a couple ways, because you're doing all of this research first to find out who the owner is and make sure you're speaking with the right person. But you probably do that in your normal listing presentations anyways, to some extent. But they're going to know, once you mention the word probate, I don't know what I didn't ask, maybe I should ask at the next presentation, but what are your all thoughts of probate? A lot of people have really bad, images of it. They think it's going to take 10 years, they think they're going to spend $30,000, like they already have a lot of preconceived notions. So when you go in there and you're talking with the person who may have just lost somebody, so they're already in a very difficult time and they're stressed out. Maybe this is this was their family home and now they can't keep it, their mom just passed away. They're already emotional, and now you say, oh, this is going to have to go through probate. You're going to have to speak with an attorney. Now they're just like really stressed out and not wanting to deal with it. So I think for you all, and a lot of, you all mostly are very experienced realtors, you'll get there. But a lot of realtors are just going, they just see that commission check and they're going in there real quick, like, yeah, we'll get this sold, and they don't know anything about probate. And I think you all, if you go in there, just by using a couple of the key terms that we spoke about and ask some of these questions, you really quickly stand out from other realtors, because a lot of realtors aren't asking those questions. They're not using that terminology. So most likely they're going to ask you 2 things, because this is the main thing I get asked all the time. How long does it take? How much does it cost? Right? That's that's going to be the main things. Like anything, I'll talk on how long is this going to take. In your all's business, a quick cash buyer close in 30 days can go from 30 days to 9 months, right? You guys have seen, maybe that's the extreme, but a lot of times you all probably you think that closings and you think, hey, everything's smooth, clean title, gonna go quickly, can very easily go from 30 to 60 to 90 days, really through no fault of your own, most likely, but something can just happen. So same in probate. I'll give you guys some numbers just to, hang your hat on and share, but again, this is just a range. So in the perfect world, and kind of like my firms, like what I hold my staff, our in-house requirements is we need to open and close the probate within 6 months. So if we don't, and when I say open, that means not from my first consultation with the client, but from the first time after they've gotten us all the information and we filed the case, from the date the case is open to the date the case is closed, I expect it to be done in 6 months. We generally uphold to that, but things can happen in between. Obviously, if brother starts fighting us, hires an attorney, all bets are off. This could go on for 2 years, if that's the case. But generally, we try to shoot for an average of 6 months. But that's the probate. For you all, for the real estate, I shoot for 2 to 3 months to get sold, because you all don't need to wait the entire 6 months for it to, we might be the person who passed away might have stocks, they might have bonds, they might have creditors, they might have a bunch of other things that we as the attorney have to deal with, but you all don't have to do that. You just need to get the property listed, sold, and that's it. So I generally I tell realtors there's kind of like a 3 to 4 month period when you all start. So during month 1, it takes us usually on average between 30-45 days to get the personal representative appointed. Like I said in the very beginning, the personal representative is the person you all are going to be working with. So at day 30 to 45, once you all have a personal representative, I say go ahead, get the listing agreement signed, and start marketing the property. After those 45 days, depending on when the person passed away, it's relevant. I would say we can get the order approving the sale done within the next 60 to 90 days, somewhere around there. So if your client is asking you how long is this going to take, you could say, well, working with the attorney, it's probably going to take around 6 months. We might be able to get this property listed. I mean, again, obviously it depends how long it takes you to get a buyer. But if you're able to get a buyer on day 1, you're probably looking at between 2 to 4 months on average to have the property sold. So, and again, anything can happen, or title might come back and we find out there's a bunch of liens on the property, and that's just happens. But our job as the attorney, what we do is we have to get the contract from you all, present it to the judge approves it, saying, okay, great, you all can sell this property, and then at that point you guys are good to go.
Can it all go through before it's even on the market, or before
No.
you have a contract?
So, well, explain that a little more. Can what go through?
The probate, can it all be?
So you have a buyer or not?
Yeah, before they even list it.
Can I do the probate before you all list it, or can you list it before the probate?
No, can you do the probate before it's listed?
Yeah. Yeah.
So it can be, I mean, you said present the contract.
Right, so if there's a contract, then we'll sell it. And you get an order from the judge, we get an order from the court saying that you all can sell the property. But let's say, it happens a lot, my clients don't want to sell the property.
Right.
Let's say, they want to keep the property. At that point, we're just transferring title.
Okay.
So we're just asking the judge, hey, this was owned, for example, this was owned by Jesus Silva, we need his interest to be transferred to Maida, and we don't sell it. It just goes to, now we just do a new deed. We get
About how long would that take?
same thing. It's the same. It's pretty much the same process.
Okay.
It's pretty much the same process.
Okay.
Yeah. It's just we're asking different things from the court. We're either asking to sell or we're asking to transfer title.
And the prices are below to the market, right? I believe I saw one listing, they say estate sale. They are lower, right?
Yeah, it seems that way.
Because if I found the one client, they had to wait all of the time, waiting if their house is on lien and blah, 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 blah. So most of the houses are listed below the other.
I don't know that part. I don't really get involved with the selling or with the the listing, so I can't speak to that. I would say though, maybe what's somewhat common, which adds a layer of difficulty to these, which it sounds like you're going through, is that if someone passes away, most likely there's probably a mortgage and now no one's paying the mortgage. So there's kind of a rush to get it sold or get the title transferred so that you can get it out of foreclosure or avoid it from going to foreclosure. And at that point, now you probably are maybe dealing with a short sale or you're lowering the price for that. But if it's a good property in a good area, it's probably not going to affect it. I mean, unless the sellers, I did a consultation with someone on Friday where they really want to buy this property. The seller does not have the money to pay the attorney, so they're going to pay, our legal fees to do the probate. Yeah, so you add that into it, but it shouldn't affect the price unless there's liens on the property and it's just a whole nightmare of a thing.
It depends on the situation.
Yeah.
Right?
Yeah.
Okay.
And then, so costs, You know, it's like everything. You can probably find someone to do it really cheap. You can find someone the more expensive end. I would say an average, you're probably looking between 3,500, 4,000 to up to 10,000. You know, somewhere.
Right?
Yeah, and it all depends. I mean, I always, you know, it's probably like you all. I get price shopped all the time. People, you know, say, "How much are you?" Well, that person can do it for that. Why are you doing it for this?
Better.
We get the same.
Similar to you all. Hey, well, why are you doing 3% instead of 1%? And you know, it's obviously quality. You know, what type of job are they going to do? And then you want to make sure that the person is going to do the entire job for you. They're not going to, you know, just to get you to a point. So I always tell, like, if I can tell they're just, you know, if they're just calling me specifically on price, I'll go through, well, this is all that I'm going to do. This is everything that I'm going to do for you. This is the level of service you're going to get from me. We're going to give you bi-weekly updates, yada, yada, yada. If my price is $7,000 and their price is $3,000 and they promise you the exact same thing that I'm promising, well, use them. I mean, you know.
I think that the smart way to ask is if I'm going through something like that, you know, this is what I need to be done. What exactly are you going to do?
Right. Yeah, and I think.
If we say how much you going to charge.
Yeah. I think it's
Because
like anything.
that's what you do. That's how much you charge.
Yeah, I think it's like anything. People, and this is again difficult. Most people, you maybe deal with like attorneys once or twice in your life, and it's never for like good things. It's either like criminal, divorce, or death. Like it's not, or an injury. It's not, you know, generally good things. What's that? It's not happy. So they're already kind of like their guard is up, and they might just not have experience with attorneys. So the default question is, how much is this going to cost? Because they don't know what else to ask. So whenever you're speaking with your clients, I would say, you know, for my preference, it's not a good idea. I don't recommend giving them a price, because if you say, oh, well, I think this attorney will do it for $3,000, maybe there is somebody who will. But if they start talking to, you know, if they talk to me and I learn that maybe $3,000 is my normal price, and then I find out, yeah, but there's 3 wills and we got to fight over them and all this other stuff. You might not have known that, but now in the head of the client, they're thinking 3,000, 3,000, 3,000. So I, you know, I'm always hesitant to give prices, but in your mind, you know, you can kind of qualify a client whether or not you think they're going to have money to pay, you know, to some extent. So that's why I say for you all, you can probably think between 4,000 and 10,000 on average, but again, it's like everything is somewhat, you know, depends. All right, then lastly in this section, which we kind of touched on a little bit. What time? Okay, we started like 10 minutes late, so are we good for like another like 10 minutes?
Yes.
Okay. If you've got to go, we're almost at 11:30, so feel free, no hard feelings. Contract. So who signs the listing agreement, sales contract for the estate? Very important, and this is really for the client. This is not so much for you all, because a title company, you know, they'll close it, whatever, it doesn't matter. You want to, the person who you're speaking with does not have the authority to sell the property on their own. So let's just say John Smith. If you have a listing presentation with John Smith, your listing agreement is not going to say John Smith, because he can't sell the property by himself. He doesn't own it. What I suggest you put is John Smith as proposed personal representative of the estate of. So John Smith as proposed personal representative of the estate, because he's not the personal representative yet, but we're asking that he be personal.
What else?
Personal representative
Oh, yeah.
of the estate of. So if, yes sir?
I was just going to ask briefly, the deceased gentleman that I was legal guardian for, I'm now his executive.
Mm-hmm.
Can I list his property?
Yeah, you'll probably need court approval. Do you have someone representing you?
The estate does.
Okay. So they named you to be executor of the estate. I would say most likely, I mean, it could be a variety of factors, but it's a law firm representing the estate. Most likely the law firm would ask the court for the authority for you to list the property. And so great example. So you're not when you sign the listing agreement, let's say, well, you're probably going to list it yourself. I don't know if you can list it yourself, but let's say.
That was my question.
Okay, so in that case, I would ask the court because you have a vested interest in selling it, obviously. So you want to just dot your I's, cross your T's. So if there's other beneficiaries and they come back and say, yeah, but why is he selling it himself? He didn't get the best price he could get. You've got approval from the court, and the court said, yeah, we know you're going to be the realtor. You can list it. So, but in this example, if you were not the person going to list, if you're the person who's going to list it, you need to write that language, John Smith as proposed personal representative. Now, when you go to sell it, when you go to have a contract, again, you're not selling the property as yourself individually, right? It's not your property. You don't have the authority to sell it. So when you write the contract as the seller, you're going to write John Smith as personal representative of the estate.
Why is that different instead of proposed and asked?
Because proposed means you're not quite personal representative. You're asking to be personal representative. So when you sign the listing agreement, you're not personal representative yet. When you sell the contract, assumedly at that point, you are the personal representative.
And so you say it's proposed personal representative of the state of the name of the person,
Right.
the owner?
Yep, of whoever died. Yeah.
Okay.
And then when you have the contract, so when you go to sell this, I forget your name, Philip. So Philip as personal representative of the estate of. That's who's going to sell the contract. That's who's going to sell the property. Again, a title company would probably close it if you just wrote your name Philip, but if for whatever reason the contract got messed up and the buyers were pissed off and they want to come after you, well, now you're on that contract as yourself, Philip. If I was you representing the estate, I don't want to be personally liable. I want the estate to be liable if something happens. So it's not really for closing purposes, it's to protect your client. Questions on that? We're all good? All right, and then last section, so marketing for properties in probate. I think, like I said in the very beginning, I think probate is a very, maybe this feels overwhelming or complicated, but once you have done one or two or had just a couple conversations, it's really pretty straightforward, I think. I mean, it's not a whole lot more complicated than other ones, and there's a great market for it, right? So it's recession proof. People are always going to pass away. I mean, it's, and in Florida,
So you're
elderly
retired.
problem, yeah. Most people don't have trust. Most people, you buy a property, when you get married or whatnot, you probably live in that house the rest of your life. You don't ever think about doing a trust, especially if you just have one property. So there's a market there. For example, in Miami-Dade, I think it's around 80 to 100 new probates are filed every month. So most probates have some sort of real estate. Not all of them. And, for example, like in our office, I think we have about 150 open, probates right now. Not all of them have property, and not everyone wants to sell their property, right? So sometimes people want to keep it as an investment. Sometimes they want to keep it in the family. So they're not all going to, you don't have 100 every single time. But that's still pretty good numbers. And I think there's an opportunity to really show value. I mean, there's a lot of realtors. There's a lot of attorneys, right? But there's not a lot of realtors who can say, when you go to the listing presentation, like, we really know probate. Like, we are going to take your hand. We're going to either introduce you to the attorney, or we're going to, make recommendations or whatever. This person has probably just lost somebody. They don't know what to do, and if you come in there and really demonstrate value to them, you're going to stand out, a whole lot from the competition, I guess. So, referral sources for you all. I think probate attorneys are great referral sources for you. Just like I said, there's there's a ton of probate attorneys. I would say I'm a little bit different in that we only do probate, but if you're like researching probate, a lot of attorneys who do estate planning, who write the wills, write the trust, they might do probate as well. I think that's a great market for you all. Attorneys, though, I will say, are difficult.
No.
It's just it's just the nature of the training, I think. So, and our guard is always up. I mean, that's kind of, we're always like trying to protect our clients. So when people are trying to, I think, get into our arena, our guard is up a little bit. But I think a good way is to try to show value, how you can add value to the attorney. Again, how can you make it easier for them? So if, like for example, the person who went door knocking and they hired, or their client now hired us to do the probate. I've never met this realtor before. And this lady, elderly lady, lived in Tampa, didn't really know Miami. The realtor and I just kind of went back and forth. We kept each other in contact. I said, I think his name's Adam. Adam, like, I've been speaking with this lady. I think you should call her. He would call her, have a conversation. He would call me back and say, hey, listen, I think, and we just went back and forth until ultimately, and we weren't trying to trick the lady. We were, giving her good information. It's like, this is what needs to happen. And we just kept each other in contact as to what's going on. Communication is key, obviously, I think, with anything, but especially with, how can you, because again, like you all going into a difficult situation for someone who's passed away, it's equally difficult, if not more difficult for us, because, they don't know us. They automatically think like, oh, I'm going to spend, $50,000 on this in legal fees. So it's, very difficult. So how can you guys provide value to the attorneys? Reach out to them. One quick example I was going to give, and then we'll wrap it up or leave the time for questions. You guys can buy lists, right? So for a bunch of different things, you can either buy, you can probably buy short sale lists. You can buy, I know there are lists. You can go to the courthouse and get lists. Nothing wrong with that. Mass emails, mass mailings are fine, but use some tact when you do it. Stand out and be different. So this is an example. I've done this presentation several times. I've yet to meet the guy, so I've blocked out his information so you can't see it. I don't know if I will at some point. But there's nothing necessarily wrong with this email, but I get this, because we file between 8 to 10 new probates a month, I get, sent emails all the time from people. I get this same exact email, just change the purchase or change the property repeatedly. So this just does not look aesthetically good on the eyes, aesthetically pleasing on the eyes. And again, attorneys, we're difficult, and by our training, we care almost too much about grammar, punctuality, all this, different types of stuff. So if you're gonna buy a list, again, I support that. I do lists, I do that sort of thing too. But find a way that you can kind of, be a little bit more personal and not just so robotic. Because you imagine, this is one person who's sending out, it's kind of like with mailers. If you guys send out mailers, there's a ton of people who send out mailers. So don't just go to, wherever and buy the same mailer that everybody else is buying. I mean, that's not a good marketing strategy. If you are to buy a list, find out ways that you can, differentiate yourself a little bit. Yeah.
So if I call you and I need you,
Yeah.
So you're working with your own title? You have to work with your title company?
No, I don't have a title company. I don't do title.
Right.
I don't do
This
title.
is not from him.
Yeah.
Yeah, that's not for me. That's
Yeah,
not for me.
okay.
That's not for me.
No,
No, I don't.
I have to ask.
Yeah, no, I don't do title. I mean, that's all.
Yeah, because a lot
Your
of
all's
clients
world.
like to work with
So
their own
you spec-
title.
Yeah.
Sorry, so you specialize just in probates, or what exactly you specialize in?
Probate.
Just
Just probate.
Oh.
So our thing is, if someone passes away and they have assets, whether it's house or bank accounts or something that have to go through the courts, that's all we do.
Okay.
Yeah.
I have a question.
Yeah.
You said that you can't do a trust if there's a mortgage? Did I understand
Yeah,
you?
generally not.
So then how do you protect yourself from having to, or your family, from having to go through probate if you have a mortgage on your property?
Each mortgage company is different, so I don't want to say across the board you can't put the property into a trust, because I've seen it done. And again, this is kind of getting a little outside of my area a little bit, but what you can do is sometimes the mortgage company will let you do the joint tenants with right of survivorship. Sometimes you can do the Ladybird deed, which maybe you all are familiar with. That's the slang name. I think the technical name is enhanced life estate deed, where basically you could say you own the property and then when you pass away, it automatically goes to this person. That's like a specific deed, so that is a way to do it as well.
I'm sorry, what is the name, Lady what?
Lady Bird deed.
So that one, when I do a closing in the future, because I purchase property with my husband,
Yeah.
so if I do that, I don't want nothing happen with my husband, of course. But should I ask to the title company, hey, can you do the Lady Bird deed, right?
Yeah.
If I wanted to not go to probate and anything.
Right.
Or the mortgage to go
Well,
automatic to me.
When you're married, you don't really have to worry about it because you're good. The title, the deed should always say as husband and wife, and then it will say with joint
But if
rights
the
of
mortgage is
ownership.
just on his name, not my name, I had to do this, right?
Well, the deed is still gonna. The deed will be in your name though.
But not the mortgage.
But
the
that's okay.
mortgage. But the mortgage is, I need to talk with the mortgage company, right? It's all depends on the mortgage.
So longer conversation, but no, generally no. I would just your whoever does the title is gonna. Mortgage and title are two separate things. So your title is gonna say you and your husband as husband and wife with rights of survivorship, and it doesn't matter what the mortgage says. The deed automatically goes to you. So if you're married, you don't really have to mess with this sort of stuff. It's more so how you want the property to go after you and your spouse pass away. That's really the main thing. So that's pretty much. I mean, that's pretty much it. Like I said, I think it's a great niche to get into. If there's more, I'll send you all some more information afterwards. Try to circulate this video as well. But if you guys have more information, feel free, give me a call. Happy to answer any other questions. Do you have anything else other than that? Thank you all for your time.
I do have one,
Sure,
but it
sure.
was a particular problem that I had. The owner had moved to Delaware. She was fairly young, reasonably young. She lived there and rented out the property. I didn't have the listing, I had the buyer. We were presented with Delaware, whatever certificate of probate, whatever you call that. Now, we assumed it was okay. We did not realize that it had to go through Florida as well. Why would it have to go through two different states?
Because it's where the property is. It's where the property is. So, because, for example, we're doing one. There's a property in Boston and a property here. So the probate has to be for the property in Boston, it has to be opened up there. For the property here, it has to be opened down here.
Then why did we have one for Delaware? I didn't understand that.
I don't.
Yeah, okay.
I'm not sure.
Okay.
All right. Thank you all.